Good evening, everybody. Keith here. Hoping everybody's having a good day. Enjoying life, living life, loving life. Gonna wait a few minutes. See if we get some viewers again tonight. Because I know all kinds of people out there getting traffic tickets. Somebody's got some questions and I got an answer. How you doing, Joshua? Say hi, everybody. I think I saw George with us. We got Noel. Greetings. Go ahead and feel free to share this live real quick. Like I said, I know there's a lot of people out there with traffic citations, got questions, and I got an answer. And one answer will clear up most all of them. I guarantee it. And I've spoken on this before. It's one of my favorite sections. So pay attention and hopefully you'll get it. I am doing wonderful, Joshua. And this is for you and the rest of my brothers and sisters as we commune together in a form of knowledge. Good evening, Bob. Like I said, feel free to share this video. Because this is one point. Yeah. This is one point that everybody can assert, and there's no way they can get around it. None. I assure you. Why? Very simply because it comes down to your word. Very simply, it proves the simplest point of my yea is my yea and my nay is my nay. Yea, yea. So pay attention as we go over this motor vehicle operator's lease. And a post I just put up not too long ago. I saw Joshua saw it already. Let me switch over. This is a very simple statement that anybody can put before a court. And it says, I believe the certification of said title to be false for various reasons. 1. Is there an obligation that I am to perform the functions of public office? I do not believe there is. And this is a valid question, as we'll see. Is there a separate written statement with a separate signature by myself wherein I agreed to use the so-called vehicle at least for 50% of its use for trade or business? While remembering, and again I'll show you this part, trade or business is defined specifically as the performance of the functions of public office. So again, I assure thee that there exists no such statement. I have never verbally made that statement, I have never vocally made that statement, and I have never literally made that statement, and neither have I ever signed such a statement. Which I assure you, it must be separate. A separate written statement, not typed or printed. This is their wording, written statement. A separate written statement from all other documentations with a signature on it separate from all other documentations and instruments. 3. In regards to all transportation and motor vehicle operators agreements, or leases as we can put it, is not a requirement or is it not a requirement to have this priority document in order to certify the title first? In other words, is it not a requirement to certification to have a written separate statement with a separate signature agreeing to use the so-called vehicle at least 50% of its use for trade or business? If that is a requirement and it does not exist, I believe before a fact can be certified, it must first be asserted. So if it's not asserted, how can it be certified? It can't. It is a false certification. Period. There is no agreement. In regards to all motor vehicle operators agreements, are they for federal tax purposes? Title 26 U.S. Codes, I got to fix this real quick. Section 7701, subsection H, clarifies the elements of the lease agreement, and one can see the purpose is for federal taxation and the abrogation thereof by assertion of certified facts that clearly do not exist. Is this, in fact, a tax court? In seeking of commercial items, known as Federal Reserve notes or other means of financial sources, all interactions with or between public officials in the performance of the functions of public office are in fact taxing events. See 26 U.S. Code 6331, levy and distraint. This is where they get their authority to levy the taxes. If they have no authority outside of the performance of the functions of public office, then they cannot tax a levy or levy a tax. Therefore, if they can't levy a tax, then what gives them permission to perform commercially? Those are the only operations that are taxable. Period. And then finally, in regards to tax issues and the taxpayer identification, is the obligor the taxpayer identification number? That's a very specific question. Is the obligor, and actually I got to fix this because they specifically state it as parentheses around a capital O and then LB or BLIGOR, stating that it's a specific definition of obligor, and then I state the taxpayer identification number, i.e., Social Security account. And I did not put Social Security account number because that is different. And I'll show you, like I showed you in 2 previous videos. I have documentation that clearly shows the obligor is deceptive in various ways of naming and numbering, proving the assumptions before the court are pure lies. That's a full out claim, people, and I stand by it. Sorry about that. I should have been putting it over here. I didn't realize my video was off. I was reading by the screen, folks. So real quick again, I believe the certification of said title is to be false for various reasons. Is there an obligation that I am to perform the functions of public office? I do not believe there is. If they are to assert that I have to have a certificate of title, they have to first prove that I am performing the functions of public office. Is there a separate written statement with a separate signature by myself wherein I agreed to use the so-called vehicle, at least 50% of its use for the trade or business, which is the performance of functions of public office that I should have already had? I assure thee that there exists no such agreement. Neither did I make an agreement to perform the functions of public office, nor did I make a separate statement with a separate signature written in my handwriting there where I agreed to use the vehicle, at least 50% of its use, for the performance of functions of public office that must already be had. In regards to all transportation and motor vehicle operators agreement, it is not a requirement to is it not a requirement to have this priority document first in order to certify the title? I believe before a fact can be asserted, certified, it must first be asserted. In regards to all motor vehicle operators agreements, are they for federal tax purposes? Title 26 U.S. Code Section 7701H clarifies the elements of lease agreement, and one can see the purpose is for federal taxation and abrogation thereof by assertion of certified facts that clearly do not exist. The abrogation is the state is claiming a tax court venue by assertion of certified facts under a federal taxation purpose through the agreement of a motor vehicle operator's lease. That the state is the one saying you need a driver's license. For what? The performance of functions of public office of the state or the federal government? Which is it? I can't serve both offices. So let's first clarify the office of the performance of functions of public office that I'm supposed to be fulfilling. And then let's find out if there's a statement that I wrote in my own handwriting and signed stating that I would then use that vehicle, at least 50% of its use, for those functions. Is this in fact a tax court? They are seeking commercial items. In their statutes of fines and penalties, they first assert the assessment on the citation alongside the road that if you don't appear in a court, there will be a certain amount assessed. Pure and simple. Known as Federal Reserve notes or other means of financial sources, whether it be they take a bond and file a fictional warrant against you and have the officers come and kidnap you, or kidnap you right there alongside the road because you refuse to sign. Who says I have to sign? And if I sign, is that an endorsement that I will sign further statements? Will it be enforced that I have to physically write a statement agreeing to further facts and elements? Or can I assert that I don't wish to do so at any time? All interactions with or between public officials are in fact taxing events. The only ones that can assert a taxing event are the ones performing the functions of public office. They're the ones that provide the distraint and levy. They're the ones that try to sit there and say what you can and can't do. That's false. They have no written statement separate from myself signed in agreement that I give them that levy and distraint. Anywhere. None. Nor do they have a written statement signed separately by myself that I am performing the functions of public office. Nor do they have a written statement separately and signed separately by myself saying I will use any vehicle, at least 50% of its use, for the performance of the functions of public office. Nowhere do they have any of those statements. None. In regards to tax issues and taxpayer identification, even if they had those statements, is the obligor the taxpayer identification number? I have documentation that clearly shows the obligor is deceptive in various ways of naming and numbering, proving the assumptions before the court are pure lies. Also see UCC 3-402B1, wherein it states, we see its signature by representative. Who's the representative? The Social Security number is the one that they say is the obligor. Yet they don't represent it as a Social Security number. I can't be liable for that. Why? Because the Social Security number is the one that gave me the authorized representation on that Social Security card. I am merely the holder, and it says in commercial use under UCC 3-402, signature by representative, if a person acting or purporting to act as a representative signs an instrument by signing either the name of the represented person or the name of the signer, the represented person is bound by the signature to the same extent the represented person would be bound if the signature were on a simple contract. If the represented person is bound, the signature of the representative is the authorized signature of the represented person, and the represented person is liable on the instrument, whether or not identified in the instrument. If a representative signs the name of the representative to an instrument, and the signature is an authorized signature of the represented person, the following rules apply. If the form of the signature shows unambiguously that the signature is made on behalf of the represented person who is identified in the instrument, the representative is not liable on the instrument. Anybody signing an instrument is not liable because that signature is made on behalf of the represented person. You are not the person. The one that gives the signature can never be the person. It is made on behalf of the represented person who is identified in the instrument. Who is identified in the instrument. The representative is not liable on the instrument. That's telling us two things. The represented person is identified in the instrument, despite what it says here, whether or not identified in the instrument. This here tells us it is identified. It is identified. So let's go to a previous look at the obligor. It is identified by a number. That number is then identified as a Social Security number, but that is not the proper style. That is not a Social Security number. A Social Security number has a hyphen after the third number and after the fifth number. This is not a Social Security number. That is a false and deceptive misrepresentation in, on, and for their financial index, relating all information as if though it belongs to myself, even through a driver license, which the certification of is false. Pure and simple. So let's look at the motor vehicle operator's lease. This is in Title 26 of the U.S. Code, Section 7701, subsection H. And when we see it says motor vehicle operating leases. Nowhere else in the code will you see anyone or the state statutes talk about motor vehicle operating leases. Nowhere. If you find it, please point it out and send it to me so I can further my research. But to this day, I have not found any. Motor vehicle operating leases. That's what they call them. It is a lease. When you get that motor vehicle license, it is an operating lease. In general, for purposes of this title, This is the tax title. So for purposes of taxation, we can replace this title for purposes of taxation in the case of a qualified motor vehicle operating agreement which contains a terminal rental adjustment clause. Such agreement shall be treated as a lease if, but for such terminal rental adjustment clause, such agreement would be treated as a lease under this title, and the lessee shall not be treated as the owner of the property, subject to an agreement during any period such agreement is in effect. Shall not be treated as the owner of the property. Why? Because they have pledged the property by registration. On one side of the counter, when you register that automobile, it is a pledge of the property. And you are pledging it to an agreement. And then the agreement isn't finalized, yet they give you a certificate of title saying it is. During any period, such agreement is in effect. Qualified motor vehicle operating agreement defined for purposes of this subsection. For purposes of this subsection has to be in accordance with purposes of this title. So again, for purposes of this subsection can be replaced. Purposes of this subsection for purposes of taxation. In general, the term qualified motor vehicle operating agreement means any agreement with respect to a motor vehicle. Not an automobile, a motor vehicle, meaning that you have to pledge the automobile first. Once you pledge it, on the other side of the counter, it is considered an acquisition. This is very important, an acquisition. All statutes and executive orders can only be implemented with contract terms and conditions, and they can only be done so while being attached to a commercial item. That commercial item is the insurances and the fines and the registration and title fees and all of that, including a trailer which meets the requirements of subparagraphs B, C, and D of this paragraph. Minimum liability of lessor. Lessee and lessor. Minimum liability of lessor. The state is the lessor, you are the lessee. You are the lessee who shall not be treated as the owner of the property because you pledged the property to the state. The state now becomes the lessor of the property because they are holding title to the ownership, and an agreement meets the requirements of this subparagraph. In such agreement, the sum of the amount the lessor is personally liable to repay, and the net fair market value of the lessor's interest, which is zero. They actually have zero interest. Therefore, the amount of the lessor's personal liability to repay is zero plus the actual liability for the harm and loss they cause. As security for property subject to the agreement, in any property pledged as security in lessor's interest in any property pledged. The only interest they have is the future use. They don't have any interest in the past use unless it has made a profit. Then they can show their interest on the paper by using their paper system. But they can't show any interest until they start a paper process. Thus, the traffic citation is the issuance of a paper process, and you are saying that you agree to have pledged the property as security subject to an agreement that doesn't exist and which has zero value, equals or exceeds all amounts borrowed to finance the acquisition. Did they borrow money to finance their acquisition? No. Of property subject to the agreement. The agreement. There shall not be taken into account under Clause 2 any property pledged which is property subject to the agreement or property directly or indirectly financed by indebtedness secured by property subject to the agreement. They are using the pledged property directly or indirectly to finance it by taking it from you and then auctioning it off for the fair market value. Guess what? Subject to the agreement. The agreement, certification by lessee. What's that tell you, people? Are we the ones that are supposed to certify this? Are we the ones that are supposed to certify this by notice of tax ownership? An agreement meets the requirements of this subparagraph, which is required, meets the requirements of subparagraphs B, C, and D of paragraph 2, if such agreement contains a separate written statement, not a separate printed statement, not a separate typed statement, but a separate handwritten statement. Separately signed by the lessee, under which the lessee certifies, under penalty of perjury, that it intends, that it was your intention. It was your intention that more than 50% of the use of the property subject to such agreement is to be in trade or business of the lessee. Notice trade or business is blue line highlighted. Trade or business is defined as the term trade or business includes. It means nothing else but the performance of the functions of a public office. Again, they first need a statement, handwritten under penalty of perjury and signed separately from myself, that I am qualified to perform the functions of public office. And then they need a separate certification that I also am going to use a motor vehicle in the performance of that functions of that public office, at least 50% of its use. They have neither, which clearly and legibly states that the lessee has been advised that it will not be treated as the owner of the property subject to the agreement for federal tax purposes, federal income tax purposes, meaning that the use 50% of, at least, in the performance of functions of public office, I must have been receiving wages or salary. I must have been recording the use by mileage to show it has been used, at least 50% of its use, or time logs showing it has been used at least 50% of the hours logged. Plus, it must have bills of lading showing products or persons being trafficked, citing the identifications by weights, numbers, measures. The coup d'etat is the D. Lessor must have no knowledge that the certification is false. If the lessee knows the certification is false because he has not made any such statements, then it is the lessee's responsibility to let the lessor know that the certification is false. Under that responsibility, the lessor must acknowledge and can no longer assert that the agreement is certified because they have no facts stating that it is and cannot prove it as such. An agreement meets the requirements of this subparagraph if the lessor does not know that the certification described in subparagraph C1 is false. Going back to C1, the lessee must certify under penalty of perjury that it intends that more than 50% of the use of the property subject to the pledge of the agreement is to be in trade or business of the lessee. If you have not made that statement, then you need to clarify to the lessor, the one certifying the title, and stating that they have title, that they do not have title and cannot possibly have title because they have no interest in title because it cannot possibly be certified. You have all interest in equitable and legal title for private use. Pure and simple. If you people cannot understand this video, I can no longer help you. This is all you have to express. I made no such agreement. The certification is false. I did not agree to pay taxes. I cannot pay federal income taxes because I do not fulfill the functions of the performance of the functions of a federal office. I cannot pay state taxes because I do not fulfill the performance of the functions of a public office of the state because I have made no such agreements. In not making any such agreements, I cannot be subject to certification to do so. Pure and simple, people. I don't care if they want to describe it as a motor vehicle. I don't care if they want to describe it as Herbie the Love Bug. I don't care if they want to call it an asshole. I don't care what they want to call it. I don't care if they want to define it by a number. Nothing. It don't belong. It doesn't fit. Remember the old Sesame Street thing, and they give you 4 pictures, and one of them just obviously don't belong? It just obviously don't belong. It's clear on the record. There exists no such statements. You are lying. And if that officer alongside the road can't discern for himself, if he can't use his own discretion, that's on him for his own cognitive dissonance, idiocy, believing that he has all of this intelligence and all of this authority and all of this enforcement. Bring it. The best you could possibly get me for is theft. grand theft auto. And if somebody's already given me their specific permission to, quote, drive it or do whatever, it's upon the state and every public official to prove that I am subject to the performance of the functions of public office first and foremost, and then to prove that I've made such statement, and then to prove that I've made a secondary statement, separate, handwritten, hand-signed, agreeing to do so commercially. Can't be done. Can't be done. It doesn't exist. It doesn't exist for me, and it doesn't exist for you unless you somehow blindly did so and don't remember it. You better start thinking about things, people. Go back and look at that post where I posted 6 questions. Those are 6 questions that will shut them down if you know how to assert them. Where is your authority to levy any tax? In order for them to levy a tax, they have to prove that it's a commercial transaction. If it's a commercial transaction, it's an attachment of a commercial item. This is proven by seeking of fines, fees, penalties, and subcharges, surcharges, and taxations upon the assessment of the charges. This can only be had through federal acquisitions regulations where contract terms and conditions are required to implement such statutes or executive items. Pure and simple. They have to have a contract with me as an acquisitioner. Not someone that pledges my property, but as an acquisitioner. No other way. I'll walk into any court they want me to. That is not proof. Granted, I recently discussed the muscular contractions that are the main and very first foremost contract in any actions, any interactions with any person, any man, any neighbor, any brother, any sister. It all depends on your muscular contractions first. You have to decide whether you want to go that way or that way. Whether you want to do it that way peacefully or forcefully, or if you want to do it that way quickly or slowly. Up to you. But I have no problem walking into any court. My body is a sacrifice. I'm told to sing, and I will sing everywhere I go. And I will sing the truth, and I will let them know that their statements are invalid. They are false, deceptive, and they carry no weight, measures, lengths, terms, nothing that apply to myself. Period. Every license out there is dependent upon a handwritten statement with a separate signature. Separate from all other documentation. Right. They will only call a person when it comes to the person. Objection, Your Honor. I'm here in the matter of that person, but I'm a respecter of no persons. Do you respect me as the man I am, as called, respect the man before this court, originally and inherently sanctified and ordained, long before he was even called by any name? Uh-oh. I guarantee you they're going to have a problem with me in any court. You either address me appropriately, or you let me leave peacefully, because I have no concern with these matters. I don't fear to walk on any court. Not anymore. Yeah, they don't have my signature. Until they have a signature, none of their commercial venue actually operates effectively in equity. In order for one man to make a profit in their commercial system, they have to take advantage of another man. I can't do that. I do my best not to. I still have a necessity of the Federal Reserve notes, so my apologies for that, but I am striving very earnestly to get out of that and show all my brothers and sisters how we can operate uniformly through barter and trade. This is why, I've been delving a lot lately, not just into the legal thing, but if you look on my man page, I've been doing a lot of things on boondocking and tiny homes and people getting lots of land where they can turn around and allow for boondockers to come in and spend some time on their property while they're harvesting crops or helping exchange labor for these large properties that single families can't operate the entire property to its full effect, but they can if they had boondockers coming in year round. So that would help these property owners that really want to make good use of the property but can't do it themselves, so they need outside forces, but they can't operate in a commercial sense to hire those forces so they can exchange those forces. So we need to bring those kind of venues together and help each other learn the different aspects of those venues as we come together in them. This is why I try to impress upon people we need to start asserting this stuff so we can start asserting our right to travel along the roads in boondock fashion. Start asserting our right to possession and usage of the land without taxation, so we can allow our brothers and sisters that are traveling across the land to come and take their rest upon our doors, and so we can shut our curtains and give them shelter and feed them and give them clothing if they need, according to the biblical scriptures, freely, divinely. It's the only way this stuff's going to work for us is if we work it. You got to quit depending on me to try to last minute chance 3 hours before you go to court and ask me how to solve the ticket. I can't do that. I've already done it. You've already got the answer. Quit looking for the answer in all these different venues. It's right there. The truth. The truth. The truth. They lie on the record. Point it out. C, the certification by lessee. That means I have to certify it. If I've never certified, then it's false. Let them know. I'm sorry, I made a mistake. Please forgive me. I'll forgive you all these fines and everything, but you no longer assess them against me because it's false. I can't do that. I'm not qualified to perform the functions of public office. Therefore, I can't second-handedly agree then to operate a motor vehicle for the performance of functions of public office because I'm not performing the functions of public office. I'm not qualified to do so. The officer, he's performing the functions of a public office. He is required to have a driver license while performing the functions of public office on the road. Pure and simple. So think about this stuff, people, and remember, I'm going to post my other forum links. I'm going to paste that PayPal link. I hope you hit that button and send me some love because I certainly need it. But at the same time, like I've said before many times, we need to start helping each other out in all these different forums. So share that information. Share the videos. Share all the links to the different forums. Share it all. Quit letting this stuff sit in the shadows. Bring it out. This is the only thing you need to defeat any traffic case. Quit asking any more questions. It's no longer a matter of question. The facts sit there. Use them. Use them against them. Every state that says they require a driver's license is dependent on it because it's for federal tax purposes. And it states so in the tax code. And that is the only place I find a motor vehicle operator lease. Nowhere else. So think about it. Share. Get this stuff out so people can start standing up for themselves. Start standing up for yourself by placing the truth on the record. The certification is false. And in the meantime, hit those links, check them out, start sharing those, and certainly help me out. Help me help you. Like I said, I've got a doctrine of necessity for the Federal Reserve notes just like everybody else, and I could certainly use it. So hit that PayPal link, share some love, and remember, if it wasn't for you guys, I would not be doing this. I don't even need to look at this stuff anymore. I can quote it verbally. I can tell them where to look it up for themselves. You guys just look at my page. It's all there. Again, I love you. God bless. Have a great night.